Hello! It seems that we are live. Welcome to this impromptu Brewster Call. Let's try this again. Welcome to the Brewster Call, a show where liberty lives, ad hominem dies, and commies need not apply. Today is the 248th birthday of our great nation, the United States of America. And so I wanted to celebrate this by reading the very documents that we celebrate on this day. For those of you who do not know, July 4th, 1776 was the signing of the Declaration of Independence. Actually, some people may not know this, it was actually July 2nd, funnily enough. However, they had to wait another day or two, and Jefferson at the time said, like, oh, July 2nd is going to be celebrated with fireworks and cannonballs and etc. But here I've got from the Heritage Foundation the Declaration of Independence and Constitution of the United States, and I wanted to read from it, if I am to be honest. Forgive me, I'm just looking at my settings. If anyone sees that I'm actually live right now, feel free to give me a shout out, say, hello Jason Brewster, host of the Brewster Call, and I'll do a bit of an impromptu Q&A. I'm functioning off of Eastern time at the moment, so it is currently 10:50 in the evening. I'm hoping that by the time I'm finished with reading the Constitution and the Declaration, it will not actually be the following day. Forgive me, I dropped my Constitution, my Constitution. I will be right back. Okay. So, this one is the Declaration of Independence. In Congress, July 4th, 1776. The unanimous declaration of the 13 United States of America. This is some profound stuff from Jefferson, so pay attention, okay? When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted amongst men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive to these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shewn that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms of which they are accustomed. Yes, this is the Declaration of Independence. Good to see you, Phoenix. Forms of which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably from the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove thus, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be ordained, and when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly for opposing with manly firmness in his invasions on the rights of the people. He has excited domestic insurrections amongst us, and has endeavored to bring the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered by only repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Let's see. Comment, hold on. Fitting day to say this, Jay. It is very likely you and I will witness the 300th birthday of America, 2076. Sure, we'll both be still around until then. We'll be old but still American. Well, that's the plan if the country is to continue for that long. I am saving my bicentennial quarters from 1976 in order to sell them off then. Let me continue now. Nor have we been wanting in attentions to our British brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and consanguinity. It's not often you find an English major who stumbles over his words, but this one's a difficult one. I will have to look it up. Consanguinity. We must therefore acquiesce in the necessity which denounces our separation and hold them, as we hold the rest of mankind, enemies in war, in peace, friends. We therefore, the representatives of the United States of America, in General Congress, assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people of these colonies solemnly publish and declare that these united colonies are, and right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other, pay attention here, our lives, our fortunes, and our sacred honor. The Founding Fathers knew they were signing their own death warrant. They knew that victory was not guaranteed, and that they would be hung and killed as traitors to the king. They knew exactly what they were doing, and yet they had the courage to do this anyways. The reason I read the Declaration of Independence, and I will be reading the Constitution very soon, is that we need to know, if we are to defend our country, we need to know what exactly we are defending. These ideas are, in the long span of history, very novel and very new and very unique to the United States of America. And the burden now falls upon us, the current inhabitants of this country, to defend it to our dying breath. In a time where everyone's decisions, it seems, carry a lot of weight to them, we need to be extra careful that we are actually making the Founding Fathers proud. I spoke to a lady today at work, and she was saying, "Oh, I don't celebrate the Declaration of Independence. I don't celebrate." I said, "Happy Independence Day," and she was like, "I don't celebrate Independence Day." And I was like, "Well, why not?" She's like, "Well, frankly, I'm very much on the left." And I was like, this should not be a Democrat or a Republican thing. It is an American thing to celebrate the country in which we have lived in, the country which has given us everything. We should not take for granted the founders' sacrifices. If you hear any audio things, just let me know. At the moment, I am trying to mess with my audio and make sure it's not blowing your ears out. Everything's in the red. If I become too quiet, please let me know. If there's any live watchers at the current moment, I doubt there is. Oh, geez, I can hear myself. Oh, that is rough. That is rough indeed. Okay. No one. Forgive me, I just set this up very, very quickly. The point being is that the woman said, "I don't want to celebrate our country," and I said, the founders may not have been perfect. I believe it was only George Washington who freed the slaves upon his death. However, they set forth the promise for a more perfect union, which we will be getting to. Just because they personally didn't follow up to that promise does not mean we should forsake it. Now I'm starting to read the Constitution. Constitution of the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branches of the state legislature. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant in the state which he shall be chosen. I will point here that I will be reading the current thing. There are some portions where it is in brackets saying that the 14th Amendment changed something, or the 17th Amendment changed something. I'm only going to read the Constitution as it currently would be our governing law of the land. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such a manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, thereof for 6 years, and each senator shall have 1 vote. Immediately they shall be assembled in consequence of the first election. They shall be divided as equally as may be into 3 classes. The seats of senators of the first class shall be vacated at the expiration of the 2nd year. Of the second class, the expiration of the 4th year, and of the third class, the expiration of the 6th year, and so that 1/3 may be chosen every 2nd year. No person shall be a senator who has not attained the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote, unless they be equally divided. The Senate shall choose their other officers, also President pro tempore, in the absence of the Vice President. That's a very interesting point, Phoenix. Please elaborate on that while I continue reading. Let's see. President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on an oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in the cases of impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except to the places of choosing senators. The Congress shall assemble at least once in every year, and such meetings shall, unless they be on the first Monday in December, and then that was taken by the 20th Amendment, unless they shall appoint a different day. It's weird, okay. Section 5. Each House shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each House may provide. I am going to switch over to the other pocket constitution provided by Turning Point USA, rather than the Heritage Foundation. I have a feeling that might be slightly more clearer. If I can find it. Fair. Aha! Found the other one. Currently on section 5, article 1. Okay. So just to be reminded, I'm on section 5 of article 1 of the Constitution of the United States. Each house may determine the rules for its proceedings, punish its member for disorderly behavior, and with concurrence of 2/3 expel a member. Yeah, no, I think this is a very fair thing, is if we're doing a originalist interpretation of the First Amendment, they wouldn't have considered like Luciferianism or Satanism to be a legitimate religion in their eyes. And so I would suppose that one may theorize that when they say that a religion is something we're free to practice, if you interpret it as originalist, that the implication would be that freedom of religion doesn't apply to Lucifer. Just as I believe in one of the amendments, I think in the civil rights, it says something about communists are not, I'd have to find it, but I'm just really focused on making sure I get this done before midnight happens here on Eastern time. It's basically Constitution speed read, go! So now it's section 5, I think, I don't know if it's clause 3 or part 3 of it's within the section. Each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Meaning that members of the House and Senate, meaning each house, a lot of this, unless it's a matter of public security, will have a public record of things, and if it must, 1/5 of those present at the time can say, hey, I want this to be public information, and they have that power. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than in which the two houses shall be sitting. That's a very interesting thing. I didn't realize that the House of Representatives has to get consent from the Senate in order to go on break. That's a very interesting thing. Section 6. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning home from the same. And for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the annulments whereof shall have been increased during any other such time, and no person holding any office under the United States shall be a member of either house during his continuance of office. So, explained, it says Section 6 prevents members of Congress from holding multiple offices simultaneously and reinforces independence from the executive and judicial branches of government. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes law, be presented to the President of the United States. If he approve, he shall sign it. but if not, he shall return it with his objections to the House in which it shall have originated. So if the bill starts in the House, passes the Senate, and then goes to the President, and then he doesn't like it and vetoes it, he can return it to the, starts in the House, so it goes back to the House. Who shall enter the objections at large on their journal and proceed and reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House. And if approved by 2/3 of that House, it shall become a law. I believe that's for overturning a veto. But in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered in the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, such same shall be a law. So if it passes both Houses, the House and the Senate, goes to the President, and he just does nothing for 10 days, it becomes law. Interesting. Where it says, after it shall have been presented to him, the same shall be a law. Yeah, interesting. In like manner as if he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be a law. Every order, resolution, or vote which the concurrence of the Senate and House of Representatives may be necessary, except on the question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives, according to the rules and limitations prescribed in the case of a bill. There's a little thing here, is a did you know portion. It says, did you know the power of the President to refuse to approve a bill or joint resolution and thus prevent its enactment into law is the veto. The President has 10 days, excluding Sunday, to sign a bill passed by Congress. A regular veto occurs when the President returns the legislation to the House in which it originated, usually with a message explaining the rationale for the veto. The veto can be overridden only by a 2/3 vote in both the Senate and the House. A pocket veto occurs when Congress adjourns. During the 10-day period, the President cannot return the bill to Congress. The President's decision not to sign the legislation is a pocket veto, and Congress does not have an opportunity to override. Section 8. Explained. Article 1, Section A of the Constitution grants Congress the ability to execute necessary steps to maintain the nation. The various clauses then identify set specific parameters to those powers. James Madison notes, without all 18 clauses of this section, Congress would have no limiting principles given the power of this clause. James Madison says, if Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one, possessing enumerated powers, but an indefinite one. So it says, 1. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and to provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. 2. To borrow money on credit of the United States. 3. To regulate the commerce with foreign nations and among several states and with the Indian tribes. 4. To establish uniform rule of naturalization and uniform laws on the subject of bankruptcies through the United States. 5. To coin money, regulate the value thereof and of foreign coin, and fix the standards of weights and measures. 6. To provide the punishment for counterfeiting the securities and current coin of the United States. 7. To establish post offices and post roads. 8. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. So I'm assuming that is the copyrights. 9. To constitute tribunals inferior to the Supreme Court. 10. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. 11. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. 12. To raise and support armies, but no appropriation of money to that use shall be a longer shall be for a longer term than 2 years. 13. To provide and maintain a navy. 14. To make rules for government and the regulation of the land and naval forces. 15. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. 16. To provide for organizing, arming, and disciplining the militia, and for governing such part of them that they may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to discipline prescribed by Congress. 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise the authority over places purchased by the consent of the legislature of the state, in which the same shall be the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And 18. To make all laws which shall be necessary and proper for carrying into the execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or any department or officer thereof. Section 9. The migration or importation of such persons as any of the states shall now existing think proper to admit shall not be prohibited by Congress prior to the year 1808, and a tax or duty may be imposed on such importation not exceeding $10 per each person. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion of the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given to the regulation of commerce or revenue to the ports of one state of those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury, but in a consequence of appropriations made by law, and a regular statement of account of receipts of expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present, annulment, office, or title or of any kind whatsoever from any king, prince, or foreign state. Explains Section 9 limits Congress' powers of taxations, regulation, and political preferences, but also grants Congress the power to use public funds and ensures a person will be brought before a judge in court before his or her imprisonment. Section 10 of, again, this is Article 1. I do want to check up on the chat and see what is going on. Doesn't seem like I've got any viewers at the current moment, which is entirely fine. I'm not doing this for the views, I am doing this for the country. Section 10. Okay, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. 2. No state shall, without the consent of the Congress, lay any impost duties on imports or exports, except what may be absolutely necessary for executing its inspection laws. And the Net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. 3. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in any time of peace, enter into any agreement or compact with another state or foreign power, engage in war, unless actually invaded or in such imminent danger as will not admit of delay. Article 2. So this is about the President of the United States, and this is very important lately when it comes to Biden and Trump and what they're up to doing. Section 1 of Article 2. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled to Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one shall not be an inhabitant of the same state with themselves, and they shall make a list of all persons voted for, and the number of votes for each, in which list they shall sign and certify, and transmit sealed to the seat of government under the United States, directed to the President of the Senate. The President of the Senate shall, in presence of the Senate and House of Representatives, open all these certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority, and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President. And if no person have a majority, then from the 5 highest on the list, the said House shall be in like manner choose the President. But in choosing the President, the votes shall have taken by states a representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the elector shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing electors on the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person eligible to that office who have not attained the age of 35 years and been 14 years a resident within the United States. In the case of removal of the President from office or of his death, resignation, or inability to discharge the powers and duties of that said office, the same shall devolve on the Vice President, and Congress shall by law provide for the case of removal, death, or resignation or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed or a President shall be elected. The President shall, at stated times, receive for his services a compensation, which shall neither be increased or diminished during the period for which he shall have been elected, and he shall not receive within that period any other annulment from the United States or any of them. Before he enter on the execution of office, he shall take the following affirmation: I do solemnly swear, or affirm, that I will faithfully execute the office of President of the United States, will to the best of my ability preserve, protect, and defend the Constitution of the United States. And Washington added on, so help me God, and then it became tradition. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he may require the opinion in writing of the principal officer in each executive departments upon any subject relating to his duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice of the consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice of the consent of the Senate shall appoint ambassadors, other public ministries and consuls, judges of the Supreme Court, and all other officers of the United States whose appointment are not herein provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, and the President alone, in the courts of law or heads of departments. The President shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions, which shall expire at the end of their next session. Section 3. He shall from time to time give the Congress information on the state of the Union, and recommend their consideration such measures as he shall judge necessary and expedient. He may on extraordinary occasions convene both houses, or either of them, in case of disagreement between them. With respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers, shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all other civil officers of the United States shall be removed from office on impeachment and conviction of treason, bribery, or other high crimes or misdemeanors. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may judge from time to time ordain and establish. The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors or other public ministers and consuls, to all cases admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same states claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. In all cases affecting ambassadors, other public ministers, or consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be in jury, and such trial shall be held in the state where said crimes have been committed. But when not committed with any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. Joseph Robinette Biden. You know where I'm going with this, but that seems like that we can get more than 2 witnesses to. He's a bit of a treasonist at the moment. Anyways, the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture, except during the life of the person attainted. Flip. Article 4. Hello. Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Person in any state with treason, felony, or other crime who shall flee from justice and shall be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed from the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall be in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party whom such service or labor may be due. Section 3. New states may be admitted by Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any other state be formed by the junction of two or more states or parts of states without the consents of the legislators and states concerned as well as the Congress. So the Greater Idaho Plan does have feet because it says that they can be formed within two or more states or parts of states. In this case, it's was it Idaho and Oregon or something. It says without the consent of the legislators in the states concerned as well as Congress. So both the states in order to make Great Idaho, and then the Congress at large. So I fully back that plan, by the way. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Section 4 of Article 4. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of this legislature or of the executive, when the legislature cannot be convened, against domestic violence. Article 5. This Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by Congress, provided that no amendment which has been made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state contrary notwithstanding. Explained. The core message of Article 6, or the Supremacy Clause. The Constitution and federal laws of types listed in the first part of the clause take priority over any conflicting rules of state law. This principle is so familiar that we often take it for granted. Now back to the actual text. The senators and representatives before mentioned and the members of several state legislatures within the executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any public office or trust under the United States. Article 7. The ratification of this conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Alright, now we move on to the Bill of Rights. This one's very important. The amendments, the first 10 amendments are known as the Bill of Rights. It was ratified in 1791 as additional guarantees that the newly formed government would protect the rights of its citizens. I'm going to take this one a little bit more slowly because it's important. Amendment number 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. So there are 5 distinct ones there. It's religion, freedom of speech, freedom of the press, freedom to assemble, and freedom to petition. Those are 5. Amendment 2. A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment is the final check and balance against tyrannical government. If all else fails, the Second Amendment is there for the people. Amendment number 3. No soldier shall in any time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. That was a thing that happened in the Constitution. The soldier would be like, open up, I'm here now, you gotta take care of me, you gotta feed me. The son basically says, if you have your own property, you can tell him, nope, get the heck out, or actually, yeah, come on in, I'll feed you. It's up to the property owner. Number 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by the oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense twice be put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Explained, I plead the 5th, saying to plead the 5th means that a person can remain silent during the line of questioning, particularly in criminal and civil trials. The 5th Amendment protects people from self-incrimination. Amendment number 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Pause. The January 6th defendants have been sitting for 2+ years in federal gulags, and that explicitly violates the 6th Amendment right to a speedy public trial by an impartial jury. Even alone being trialed in Washington, D.C. is the impartial part out of it, but they've been sitting in gulags for 2+ years without a speedy trial. That is not speedy. I would not want to wait 2 years for a trial. Come on now. Of a state and district whichein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. That's another thing. They have to be informed of the nature and cause of their accusation. They haven't even been told, like, yeah, you're just here. No pre-trial, like, it's pre-trial detainment. It's so stupid. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of a counsel of his defense. 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial and jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Explained. It forbids federal courts from creating new governmental powers through their own interpretation of the law. Citizens also have additional rights to those mentioned in the Constitution of the United States, known as non-enumerated rights. And the 10th Amendment, this one is a very important one for me. I rely on this one a lot. Powers not delegated to the United States by the Constitution, nor prohibited it to the states, are reserved to the states respectively and or to the people. So there's a lot there when it comes to, in the Article 2, Article 1, Article 1 is about the legislative branch. So if it says that, these are all the things that the legislature can do, but it doesn't, it's something that it's isn't clear, can the legislature do this? But it also, there isn't anything saying the states cannot do this, it means the states can do it. 11. The judicial power of the United States shall not be construed to extend in any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or citizens or subjects in a foreign state. Amendment 12. This is a big one, long, objectively takes up a whole page. Electors shall meet in their respective states and vote by ballot for president and vice president, one of whom shall at least not be inhabitant of the same state with themselves, and shall name in their ballots the person voted for as president, and in distinct ballots person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and then all persons voted as vice president of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed by the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, shall open the certificates, and the votes shall then be counted. This is effectively a rewrite. I'm just pausing here because I don't want to reread the entire thing. If you go back to, that is Article 2. Yes, Article 2, Section 1. Starting at Clause 3, the electors shall be in their effective states. This effectively before this amendment, before the 12th Amendment, whoever got second place would be the President of the United States. So imagine Trump, if there was no Amendment number 12, just poof, gone, never existed. 2016 election would have Trump as the President, Hillary Clinton as the Vice President. See how crazy that is? And so what they ended up doing is, okay, you have to make distinct, the President and the Vice President are on the ticket together, and all of these people, all of the electors shall vote for the President and the Vice President, so that way it isn't just first place, second place. This was after Thomas Jefferson. The election of 1800 was a crazy one, and Aaron Burr became the Vice President simply because he got second place, and it was just a crazy thing. Amendment 13. Neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Here's the thing, is it's saying that except as a punishment for a crime whereof the party shall have been duly convicted. So apparently you can have a slave or involuntary servitude to a prisoner. I don't support that clause in the 13th Amendment. I think that if you're a prisoner, you serve your time, and I don't know, I take issue with that one. It's still the supreme law of the land, but if there was ever an amendment to be made, I'd like them to not repeal the 13th, but rather just to change the wording to make it so that way slavery is just outlawed outright, including if you're a prisoner. I don't know why they have that. Section 2, Congress shall have power to enforce this article by appropriate legislation. Okay. Section 14, or Amendment 14, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of persons of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote in any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of each state, being 21 years of age, and citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in proportion to which the number of male citizens shall bear the whole number of male citizens 21 years of age in each state. Section 3, no person shall be a senator or representative in Congress or elector of president or vice president or hold any office civil, or military under the United States or under any state who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of the United States to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 and each house remove such disability. Section 4, the validity of the public debt of the United States as authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but in all such debts, obligations, and claims shall be held illegal and void. Section 5, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Amendment 15, Section 1, the right of the citizens of the United States to vote shall not be denied or abridged by the United States by any state on account of race, color, or previous condition of servitude. Section 2, Congress shall have the power to enforce this article by appropriate legislation. The 15th Amendment enabled all men the right to vote indiscriminate of race. However, voting was not extended to women until the 19th Amendment. Number 16, ratified February 1913. Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. This is a crappy thing. So, the income tax... Wait, no, I'm confusing it with property tax. A general principle of government. The property tax was initially made as a temporary measure to pay for the Civil War, and yet we still have to pay property taxes to this day, because when you give a right to the government, they do not easily give it back to the people. Number 17, the Senate of the United States shall be comprised of 2 senators from each state elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors, the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct. This amendment shall not be so construed to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. Amendment 18, Section 1. After 1 year from the ratification of this article, manufacture, sale, and transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof of the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress and the several states shall have the concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of submission hereof to the United States to Congress. Keep this one in mind, because they pulled some shenanigans to get rid of prohibition, but I think it's funny. Section 19. The right of citizens of the United States to vote shall not be denied or abridged by the United States on the account of sex. Gave women the right to vote. Congress shall have the power to enforce this article by appropriate legislation. Amendment 20, Section 1. The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January of the years of which such terms would have ended if this article had not been ratified, and terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year. In such meeting they shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall be President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified. And the Congress may by law provide for the case wherein neither a President-elect nor Vice President-elect shall have been qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have been qualified. Section 4. The Congress may by law provide for the case of the death of any persons of whom the House of Representatives may choose a President whenever the right of choice shall be devolved upon them, for the case of death of any persons from whom the Senate may choose a Vice President whenever the right of choice shall be devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article, which was ratified in 1933. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Amendment 21. So this is Amendment 21 repealed the 18th Amendment. They were like, you know what, this prohibition thing, it really stinks because we wanted to get rid of alcohol, and it ended up making more alcohol sales and speakeasies and gang violence. And so, but it's a constitutional amendment. How do we get rid of it? With another constitutional amendment. That's right, folks. The 21st Amendment was passed to get rid of the 18th Amendment. It states Section 1, the 18th article of the Amendment to the Constitution of the United States is hereby repealed. Section 2, the transportation or importation into any state or territory or possession of the United States for delivery or use within of intoxicating liquors in violation of laws thereof is hereby prohibited. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions within the several states as provided by the Constitution within 7 years of the date of submission hereof by states of Congress. Yeah. That's that. It repealed an amendment. We're almost done. Amendment 22, Section 1. No person shall be elected to the office of President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term which some other person was elected President shall be elected to the office of president more than once. So, in cases when a president died less than halfway through their term, the vice president can serve 2 consecutive terms after that. But if it was, for example, let's say Biden croaked right now, Kamala took over, she could only serve out the rest of Biden's term and get reelected once. That's how I'm reading it. It could be wrong. But this article shall not apply to any person holding the office of president when this article is proposed by Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within this article becomes operate, then holding the office of president or acting as president, yada yada. Acting as president during the remainder of such term. This basically says that all of the stuff above, if you're president right now in February 1951, it doesn't apply to you, and you can go for infinite things until you die, but that's not what happened. Section 2. This article shall be inoperative. Again, Section 2 of all of the most recent. This article shall be inoperative. It will not apply unless it is ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states, again following the process of how to amend the Constitution, within 7 years from the date of its submission to the states by Congress. So once it's submitted, it has 7 years to be ratified, and then if not, it's inoperative. Amendment 23, Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators in Congress to which the district would be entitled if it were a state, but in no event than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Explained. The 23rd Amendment grants residents of the District of Columbia the right to vote for president and vice president. Previously, citizens residing within the district could only vote if they were registered within a state. And the 24th Amendment, this one, wait, no, there's still more. There's still more. It's 1201. It's July 5th, everybody, but still. We're celebrating its MAGA month, its freedom, all month long, and we're going to celebrate it regardless. Amendment 24, Section 1. The right of the citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. Section 2. Congress shall have the power to enforce this article by appropriate legislation. Explained. An American's right to vote cannot be disenfranchised through a poll tax. Americans cannot be expected to pay a fee to vote. Amendment 25. Section 1. The 25th Amendment says, in cases of the removal of the president from office or his death or resignation, the vice president shall become president. Section 2. Whenever there is a vacancy in the office of vice president, the president shall nominate a vice president, who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he submits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Did you know? The 25th Amendment has only been invoked 6 times. I'm assuming after this it's probably a bit more because of Biden having a colonoscopy. The 25th Amendment is only invoked 6 times, most notably when Presidents Ronald Reagan and George W. Bush underwent minor medical procedures. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments of each state, executive department of each of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Biden. The Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and the majority of either the principal officers of the Executive's Department or such other body as Congress may by law provide transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers of Congress and the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of office. Amendment 26. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by any United States or any state on account of age. The Congress shall have the power to enforce this article by appropriate legislation. And the most recent amendment to the United States Constitution is the 27th Amendment, ratified in May of 1992. It says, no law varying the compensation for the services of senators and representatives shall take effect until election of representatives shall intervene. Did you know the 27th Amendment was originally proposed in 1789? It was actually one of James Madison's original 12 amendments to the Bill of Rights, the first 10. It wasn't ratified until 1992. The 203 gap is by far the longest delay of ratification for any constitutional amendment. So what it is like, I heard the 27th Amendment was a law student, and was looking through the original 12 amendments and figured out that there was no thing saying like, oh, if it isn't passed within a certain amount of time, and therefore he theorized it's still alive. It's still, if Congress were to pass this right now, it would still be a thing. There's another amendment. There was 12 originally, and then passed 10. I forgot what the other one was. I'd have to look it up, but the 28th Amendment could be the very same by that same legal proceeding that passed the 17th Amendment. So everyone, thank you for sitting through. It's been a long hour and 19 minutes. Holy cow, I have been reading on for so long. But this is what it takes to be an informed citizen of this nation. We must know the laws, the supreme law of the land to which we celebrate, to which we are to defend. It is essential for us to get smart and to actually know the things and the principles we are to defend. Otherwise, where will our nation be? This is Jason Brewster, host of the Brewster Call, signing off. And be sure to spread the calling. God bless.